Welcome to the Jersey Justice Podcast, featuring your hosts, attorneys Gerald Clark and Mark Morris.
All right, so we got the great Ed Capozzi here. Ed, thanks so much for coming in. But I do have one question I got to bust your chops on. Why the hell are we wearing suits on a Friday?
I always wear suits, so I actually am more comfortable in a suit, believe it or not. So I like to wear suits. So
That's
why I
cool.
wear them every day. My group and my firm is the only ones who dress every day. The rest of the firm does a lot of the casual stuff, business casual, but my group, the 10 of us, we wear suits every day.
Oh, really?
Yeah.
Actual suits or jacket and ties?
No, actual suits. That's my rule, one rule I have.
So when I was in law school, I would my hours were all messed up because I would sleep late. I would study till like 4 or 5 in the morning, and then I'd sleep. But I felt like when I was in sweats and a t-shirt, I would get bang out to work. How are you guys like? And when I'm at an office, I get the idea because, like, you're in a suit, you're more professional. You're gonna be more disciplined. But I just find it like physically uncomfortable writing a brief and doing the labor of being a litigator in a suit. What do you think about that?
Well, it's funny you should mention that because one of the only times I don't wear a suit is when I'm prepping for a trial.
Right.
Then I'm in sweats. I'm nose to the grindstone kind of thing.
Exactly.
I don't wear a suit. It's the only time probably I don't.
You know, I had a trial. It was about a year ago, and it was in Hudson County, and I've been learning since COVID, like the world's gotten a lot more laid back and relaxed. I mean, there was remember, Mark, there's at one point in COVID when we were all like supposed to die.
Yeah.
Remember that, like early on, like it was going to be a dark winter and everyone was going to die. So then people were like, oh shit, well, since I'm going to die, I guess I won't work as hard and I'll enjoy things more and I'll dress more comfortably.
Yeah. No, I remember that. Walking around the neighborhood, you're passing your neighbors, like, not sure what to do.
Yeah.
But
That was a crazy time. But yeah, exactly. Ever since then, nobody wears suits anymore. I mean, it's different.
So we had on Ivan Maisel on here yesterday. He's kind of like a storied guy. He was the #1 college football writer for ESPN and some others. And we were talking college football a bit, and he was describing like, I guess it was, who was the guy at Notre Dame? Newt Rockne, I think. Newt Rockne was the Notre Dame coach, and then it switched to this guy Leahy, and he wrote this awesome book about, I think his name is Ed Leahy, who's one of the most winning coaches in history, but people don't know about him because he wasn't that well liked. And he was saying that when the coach before him wouldn't switch any of Newt Rockne's plays because they didn't want to mess anything up. And then Ed Leahy switched the plays, and I asked him, I'm like, is it kind of like war? And, you know, where a new war invention comes and then they invent a countermeasure for it against it. Do you find that like in trials? And I mean, you've written this awesome book, The Domino Theory. It's like a famous book, and we've used it. And by the way, I pulled this off my shelf, and it's got highlights and flags because I use it to prep for trials. And you were talking about there was a first edition. I have the second edition. You got a third edition. Can you talk about that a little bit in trials, how the defense, the insurance will come up with tricks? And this isn't all about tricks, so tell us about that too. It's about truth and justice and what's real, but you have to come up with countermeasures to do that. You want to talk about that a little bit?
Well, when I became a lawyer, I didn't have anybody. I didn't work for a big firm or anything like that. I didn't have anybody. Well, I did in the very beginning, but not with trial stuff. That was more with like discovery type stuff. I worked for this firm, Levy Angstreich in Philadelphia, which was a plaintiff's medical malpractice firm. So that's where I started. They kind of taught me how to be a lawyer. How to take it so seriously and be very, very thorough. I mean, we were doing medical malpractice, so you really had to know the medicine. So when I moved to New Jersey and became a personal injury lawyer, that we didn't really do a lot of med mal. I did because I had the experience from Philadelphia, but I worked for a very small firm and won a bunch of trials right off the bat. I mean, it was literally my first day of work, and they're like, "Do you want to try a case?" I was like, "Yeah, I'd never tried a case." I said, "Yeah, I'll go in there and try it." So they're like, "Get $5,000." You know, it was a rear end hit on the George Washington Bridge with 2 cars. So get $2,500 from each defendant. So I went in to ask for the $2,500, thinking the case was going to settle. They were like, "No, it's a no pay." So I have to try the case. I end up getting a $300,000 verdict. So after that, my boss is like, "You're trying every case from now on." So after that, and I was winging it. I was just doing.
Where were you before that? Like, when did you get sworn in as a lawyer before that?
I was a lawyer. Like I said, I was working in Philadelphia
At Levy-Anstreich.
Levy-Anstreich. So I didn't try any cases there.
Got it.
So after I was done there, the reason I left there was because my son at the time was a senior at Queen of Peace High School. So he played sports. I wanted to see his sports. So I wanted to, and this was actually in Bergen County. So I said, I want to live as close as I can to Yankee Stadium. So I got an apartment in Fort Lee.
Yeah.
I got a job in Fort Lee. And then that's how I started working.
So how long had you been a lawyer when you get this $300,000 verdict on a no-pay case you were hoping to get $5,000 on?
A year and a half.
Wow.
Maybe less, maybe a year. It's probably right around a year, I'd say.
Yeah.
And then interestingly, then I tried the case Aga v. Feiner, which began
What was the amount of your second verdict?
440. I mean, I was getting
All right, so let me think.
every verdict I got was excess. I won like 30 trials in a row.
So my first trial, since we're all competitors here, Mark and I aren't competitors, but you and I are competitors because we're in the same field. So we're gonna compete. So my first trial was in the State Farm Fraud Department. They had put it in a fraud and say it was a fraud case. So it was the same deal. I had been a plaintiff's lawyer for less than 6 months, and they said go try it. And I remember, it's a funny story. Anyway, it was in Bergen County. It was a $120,000 verdict, and it was Judge Smith in Bergen County. But I remember during jury selection, it was like, if you could have lunch with any figure, living or dead, who would it be? And the one juror said John F. Kennedy. And it's like, oh, okay, cool, John F. Kennedy, whatever. And then in the case, I think it was the neurologist that treated the plaintiff was Dr. Hadry. And the lawyer who first represented the plaintiff was not his brother, Nazare Hadry. Yeah. So they made this they made this whole big shebang about this at trial, the defense lawyer and the lawyer, and he refers him to his brother to treat. And I remember that in closing. And I addressed it. I said, you know, they made this whole thing about that the first lawyer that represented her before we took the case home referred it to the brother to treat the woman. And they said that that's somehow nefarious or wrong. And I said, there's nothing wrong with that. They have a professional relationship, and there's like precedent for it. It's happened before. You take John F. Kennedy, the president. His brother, Robert Kennedy, was the attorney general. And it was a great working relationship. It was professional, and the juror like smiled. All right, sorry, since we're competing. And
it's funny because I had Dr. Hadry on the stand, and he went to Yale.
Yeah.
And one of the jurors, when we were selecting the jury, said, talk about her kids. Said both of my sons go to Yale. So I must have mentioned Yale 50 times in the trial, and then Hadry had actually gone to Yale. So I understand what you're saying.
That's funny.
My second verdict was Bergen County was $805,000 on whatever. People didn't think it was a good case. It was a terribly good case. It was really sad what happened. But you guys talk about countermeasures.
Well, I want to talk about Bergen County for a second. So, I tried a lot of cases in Bergen County. So I tried a case with a rear end hit. This was before Brenneman. I don't know if you know Brenneman, with the photos.
Yep. Brenneman DeMello, I think is the case.
The Brenneman case, which I guess gave birth to the charge. Big accidents can have little or no injuries, and little accidents have big injuries, which is the best jury charge ever.
Describe that for people, because we're lawyers. And Mark's on trial right now.
Okay.
And what your perception is of how jurors take that charge.
Well,
tell people that aren't lawyers, though, how that matters. And
so I tried this case before this Brenneman case, and we'll get into that. And what they used to do is they used to bar photographs. If you didn't have an expert, a biomechanical expert or an accident reconstruction expert, photographs of the damage to a car were inadmissible. So I had a case with very little property damage.
But why do you want photos of damage to a car in a personal injury case? You're just talking
want them if it's big damage, and when you see the car, like, oh my God, somebody must have gotten hurt in that case. So when you have little damage, without an expert, they used to say you needed an expert to say whether or not that damage coincided with the injury per se.
Yeah.
So in this particular case I tried, because Brenneman didn't exist at the time, the pictures of the car did not come in, and there was very little damage to the car. So the woman had just had chiropractic treatment. That's it. So I got a $1.5 million verdict on one bulge with chiro treatment. They appealed it, obviously. And the funniest thing about it was when the judge asked the jury like what the verdict was, they said the foreperson was an Asian gentleman, and he said 1.5. And the judge almost fell out of his chair. I mean, he went, "What did you say? 1.5 what?" And they're like, 1.5 million. And the judge almost fell out of the chair. And he had tried to get me to settle the case for $7,500 before it started.
Yeah.
So they appealed it. It went up to the appellate division. Then I lost. They threw it out. It said it shocked the conscience, of the judge.
Was it Judge Donahue? Do you remember?
No, it was Judge Toscas.
Okay.
Yeah.
You guys talk about being competitors. I'm sitting here with a complex. Talking about $800,000 verdict, second try. You're getting.
Oh God, he's under talking. He resolved the case for like $2 million, where a dude was Tell about the case.
A guy was at a hard rock concert basically, and people were stage diving, and he's in the mosh pit area, and someone dives off the stage, lands on his head, paralyzes the guy.
Oh my God.
He made a good recovery and things. He's back to biking, skiing, but it was a long road. And
It's a tough one.
yeah.
But we sit here and we talk about this. Like, to me, do you study or look at like Rick Friedman stuff very much?
Well, it's funny you should say that. So Rick Friedman is also an author for the same publishing company that
Trial
I am.
Guides, yeah.
So I've done a lot of seminars with him. I was telling this story the other night at that Trials and Triumphs seminar. When I first, because I was trying cases basically with no guidance whatsoever. I was just kind of doing what I felt was right. And some of the rulings, like, that you can't tell them it's an insurance company on the, sitting in the defendant's, like, they just blew my mind.
Yeah.
So I would like really bend the envelope. I would do, for example, if there was a no pay, I would tell the jury, you know why we're here? Because you know what they offered him? 0.
Right.
And so I got appealed on that issue. And I said, because of the offer to compromise, Rule 408, the jury shouldn't know if you were trying to settle the case and they made an offer on the case. It kind of shows maybe they're at fault, if they're making any offer on the case. So any offer is inadmissible. However, my argument was, well, they didn't make an offer. So how could it be an offer to compromise? Because they offered 0 on this case.
I think what's the way to say it is, and we're here because th've refused to accept a responsibility.
Yeah.
Well, that's probably the way I say it now, but back then,
More
like
refined.
I'm much more refined now. I got appealed so many times when I was younger. We're
talking about like Rick Friedman. What I'm getting at is, like, is this just who can get more money? See, what I've learned as a plaintiff's lawyer in recent years, maybe 5-10 years, and largely from studying Rick Friedman, is it's about right and wrong and justice. And when what happens, and people probably know if they listen to the show, when someone gets in an accident, they file a lawsuit, you go to a lawyer, the defense insurance company is going to send you to a doctor. And the doctor is inevitably going to say your injury, you're either faking your injury's from before, and there's these unscrupulous defense medical exams. And actually the article I wrote up there for the Law Journal talks all about that. And we've had these exams. We send a nurse, and we'll get to this. And we could have this podcast for like 4 days because we have so much stuff we want to talk about.
Yeah.
But they have those unscrupulous defense medical doctors. And Rick Friedman writes about, are you the same way, where you have a crappy case and you send them to someone and, the guy that is going to give you a good report? And so what I've learned in recent years is there's a moral thing to this. There's a right and wrong, justice, moral thing. It's not about who can get the most money. That's what I've learned in my thing.
Yeah, and this is what I was getting to before with that seminar we did the other day. When I first, because I wanted to learn, but every time I bought a book, like a Rick Friedman book, or like I said, people are always recommending these different plaintiffs' books, Rick Friedman, The Reptile, things like that. I would read it, and as soon as I read it, it would say, never do this or never do that. And I would be like, oh my God, I do that in every case. So I stopped reading the books because they were kind of scaring me.
But you were winning a lot of those cases.
Yeah, I was winning them on my own without. Right. So I stuck to my guns. And then when I repped the Reptile Friend, this is why I use this as an example. I read it and I was like, wow, this is very cool. Like, I want to try this. But I was already winning my cases my own way, and I attempted to do this Reptile. And when I was talking to the jury, I didn't feel comfortable. It felt unnatural. So and it just didn't feel right, and I lost. And I tried it 3 times, and I lost 3 trials in a row. I then put the reptile down, and I went back to my old ways. And I won 10 cases in a row because I was like, "Oh my God, I lost my touch." Wow. I lost 3 in a row. I went back to my own way, won 10 in a row. Then I started to read these books, and I've read them all. Read every book of it, even the 10 Commandments of cross-exam. Never ask a question you don't know the answer to. I do it all the time, only because I know that there's no answer. Whether it doesn't matter what the answer is going to be, it's going to be bad for them.
Right.
When I have them in such a tight, I got them dead in the water. So I'll ask an open-ended question. They cannot answer it. And I'll let them explain. I'll just let them ramble on. I'll say, so it's exactly what I said it was.
Are these tricks where you're winning cases you shouldn't win because really the plaintiff's not injured, or are they techniques to expose the truth and the bullshit that the insurance companies do?
No, most of them. Well, I won't try a case that is fake or fraudulent or like that. I
Right.
literally, the cases I try, and it's probably, I almost died recently. I don't know if you know that, but
You mentioned that.
it's because I am so into these cases. Like, I give it my all.
Yeah.
Like, when I'm done giving a closing argument, I literally get on my chair and I almost pass out. I've left it all out there.
Right.
So I believe in my clients. I believe in these cases, and I despise the insurance companies so much. I'm so passionate about it that I literally would die in a courtroom for these people.
Right.
Because they are so crooked, and it's so bad. Like, if you could just expose, and I try to explain this in my book too, I think, if you can just expose, like, what we know about the defense insurance companies,
Yes.
and with the IMEs,
Half of which we're not allowed to
Yeah.
tell the
Yeah.
jury.
if you could just let that jury know what they're doing, and the amount of what they're doing, because they're biased, but it's not about being a little biased. They are 100% of the time. I've gotten 12,000 reports from certain defense doctors, 12,000 reports where not one person's injured, 0.
Wow.
And then the other expert in the same case, 6,000 of his reports, 0 people ever injured. So that's 18,000 reports by these 2 doctors. If you could expose that to a jury,
Right.
they'll be like, come on. What do you think they sent this person for? So I'm very, very passionate about doing this, and I give my all, 100% on every single case.
Mark, talk how we do. You know how we get the JVRs?
Yeah.
Tell about how we do that, because Mark's on trial right now in Monmouth County or Middlesex County.
Yeah. So we had a recent case. It's funny, and another attorney from our office was going to do the cross-examination of the defense doctor. He's been here for a while. I was like, you know what? You're ready for this. You can handle it. I had something else. It was a case I was working on. And he calls me. It's about like 7 o'clock at night. And he's like, hey, Jerry's actually going to do this guy's cross-examination. And I go, okay. So Jerry's got this. And Jerry, by the end of the night into the next day, had, I want to say it was probably 50 exhibits marked of jury verdict research where this defense doctor testified, no permanency, predated the crash, degenerative, or, predated the incident, all that. He had transcript after transcript highlighted where the guy testifies the same thing over and over, not related to the incident, pre-existing, degenerative, and just exposed it. And we got to settlement conference. It was a trial call. It wasn't a settlement conference. There'd been a no pay on this very difficult liability case. And lo and behold, yes, no confidentiality. It was ended up paying, I think it was over $500,000. On a case that had been at a no pay, it was a 0 ARB award. So the way we approach that, and I'd imagine if you're getting 18,000, JVRs, very similar. Like we dive into it and we try and expose as much of the BS as we can.
Well, I've been trying to get everybody in the NJAJ, for example, and for those of you who don't know what NJAJ is, it's the plaintiff's bar organization in New Jersey. It used to be called the New Jersey Trial Lawyers Association. So in the United States, it's America's Trial Lawyers Association, ATLA, and then each state has their individual chapter. So in New Jersey, it's the New Jersey Association for Justice now, which I never agreed with the changing of that name. Trial lawyer. I'm very proud to be a trial lawyer, as I'm sure you guys are as well. So when they changed it, they said, it's a very negative connotation, like connected to that word trial lawyer. So the New Jersey Trial Lawyers literally changed their name to the New Jersey Association for Justice, which I think is lame.
Wait, you're saying they thought trial lawyer was a dirty word?
Yeah, they did some type of research on it, and they hired some marketing company, and they said, trial lawyer is one of the most dishonest words in the human language, and so They changed the name, and then everyone in the U.S. did also. Even American Association for Justice now, it doesn't not American Trial Lawyers Association. There are some states that are still called Trial Lawyers Association that didn't change the name, but 90% of them changed the name to Association for Justice.
Yeah, but what that is, there's a book, I forget who wrote it. It's in my office. It's called Words That Work.
It's actually on my bookshelf. I took it from you. But yeah.
Do you remember the author's name? Or
I don't. I want to say no. I'm guessing Heller, but I don't think it is that.
So there's a book called Words That Work, okay? And it's written by a political consultant. And he would counsel people in Congress, the legislatures, like it was called the death tax. And it was called the death tax for many years. And people are like, shit, I get taxed when I die. And then he said, you got to change the name to the estate tax. It sounds like a tax on rich people. Oh, and then it passed, right? Yeah. And then along those lines, gambling is now gaming, right? And it's not drilling for oil, it's energy exploration. So the problem with the trial lawyers is, and maybe you want to talk about it a little bit, is like the McDonald's coffee cup. And what people should know out there is that these insurance companies, like you say, I can't tell the jury what's really behind they're seeing here. So at trial, they'll see a lot of times they'll see maybe a defense lawyer, maybe they're not dressed that well, maybe they look like they're bumbling around a little bit, which is often a facade because behind that defense lawyer is a multi-billion-dollar industry that's supporting this all. Sure. And what they did after the McDonald's coffee cup verdict way back in the early 90s, I think it was, is they put millions and billions of dollars into marketing to defile plaintiffs' lawyers and trial lawyers so that when jurors show up in court to serve, a third of them are already biased against trial lawyers, and that's why they changed the name.
Yeah, well, I understand why they did it, but I wouldn't have done it. I mean, personally. Like I said, it gives it a negative connotation when it's actually it's a noble profession, I think. So just because of the propaganda that's, obviously defense propaganda, insurance company propaganda. I mean, I can't tell you, and I'm sure you guys have the exact same experience, how many times a McDonald's coffee case comes up in selected jury.
Still these days?
Every day, all the time. And I've had probably 25 McDonald's coffee cases come to me to represent them, in a similar cases since that. I always reject it.
We've settled a couple of them.
We have.
Mark handled one.
We like very kind of lower value type ones where like newer attorneys. I can't remember if we've had a bad burn one.
I've had some bad burns too, but I'm afraid to do it because I don't want to be on the front page of the paper saying, "Oh, another, ambulance chaser."
So Rick Friedman, and as I said, I've learned that the morals behind what we do, and Rick talks about, trial lawyers are kind of like the last defense in a large culture war, and control of the nation, control of the resources, control of the levers of power. You want to talk about that a little bit? I was at your seminar, Trials and Tribulations, you were presenting alongside people like Justice Albin and Chris Placitella, and that's one thing Chris had talked about there. Do you want to talk about that kind of bigger dynamic of what's really behind trials and the pressures of tort reform and all this stuff to limit people's rights and access to courts?
Yeah, and that McDonald's coffee case is a perfect example because there's so much propaganda. Like when we walk into a courtroom, the jury is 100% against us because the only reason they're there is because we're bringing this lawsuit, and so that you could see them, huffing and puffing and moaning and groaning, and there's 100 of them in the room, and the process is long and it's boring, and a lot of times they might sit the whole day and not even be asked a question, and I don't like to bring my clients to the jury selection only because they're sitting there and the jury's looking at them literally the whole day, and like eyeing them up and down and making sure they don't look hurt or whatever, but at the same time, I want them to come only because to get them to hear when I try to tell them how negative this jury's going to be, and the stuff they say is like, oh, they're all full of crap, they're all frauds, they're all in it for the money. I mean, you must hear that 50 times. So for the first 100 people that they bring in the courtroom, 75 of them leave because they say they can't serve, they have a hardship or something, I got a vacation. They have every excuse in the book. The other ones are all like, well, they're all full of crap. So you go in there like, oh my God, like how am I going to win with this jury, So you have to do such a good job that not only are they not against you anymore, but they're now on your side and they want to give you money. So, I mean, it's really hard. It's a hard job. It's very hard to do, especially, some of the soft tissue, neck and back stuff, which, anybody, until you've been hit by a car, rear-ended, for example, and have the whiplash like a rag doll in a car. You get thrown around like your body bends in ways it's not supposed to bend.
Yeah.
It's just, I always use this as an example when there's not a lot of property damage. If you're standing in a room and somebody sneaks up behind you and shoves you as hard as they can in your back, your neck is going to snap in half. You're going to get injured.
Yeah.
So, it's a very, very, very hard thing to do. But I think you have to believe in your case and be yourself and, try to prove to them, like what we know. Like I said, I want to make it obvious to them what we know, like how bad it is with the defense, like what they actually do. It's crazy.
So, you want to tell an anecdote on that, or?
I was just going to say something real quick because this is the probably first time in years that I've worn a suit every single day this week because I'm in trial right now. But the case I'm on trial on, the defense is called One Witness, and it's a defense doctor. And we took the guy's de bene. We took his trial testimony before trial. For the past 5 years, he's made all of his income testifying 100% of the time on behalf of the defense. The guy makes, I think it's around $300,000 a year, probably more than that. It's been $1.5 million the past 5 years testifying for the defense. And the stuff we read, we look at, they could have picked anybody. And this is the guy they picked to come in and say this stuff. So, yeah, it is. You wish you could tell the jury everything, like, hey, we've seen this doctor 20 times before. He writes the same thing every time, and you kind of can. But it's such a fine line. And like you're saying about the insurance, you can't mention insurance. It's you want to pull your hair out when they say, I'm here on behalf of this guy. And you're like, who? Where is he?
Yeah, surprising. Like you would think the jurors would realize that it is an insurance company because they always ask, like, where's the insurance? Like,
but that doesn't always help the defense because a lot of the jurors are like, oh, we can't, compensate this and make up for this because our insurance rates will go up. So we're up against that issue too.
It's true. But I don't know if I'd rather have that or the little old lady who looks like she couldn't, afford a sandwich is now the one who's going to have a $1 million verdict against them.
Yeah, that's why I think Andy Frazier. I mean, Andy Frazier is another storied New Jersey attorney. On the side of on the good guys for justice. He's a personal injury attorney, and he gets these very, very healthy verdicts in conservative counties like Bergen County, and he'll flip the whole conservative thing too, because he'll say, and there's no caps and no government should tell you how much something is worth. So he flips that narrative too to his advantage. He's really effective.
Yeah, I know him well. I mean, and it happens, and this would happen when I was first winning a lot, especially in Bergen County. I don't know if you remember, they used to have a book like out on the council table with all the verdicts in it.
Yeah.
Oh, really?
I remember that.
They would have every verdict for the last 3 or 4 years. So the judge would say, if it was a new judge I didn't know, and they'd say, he'd show me the book. Oh, look at all the no cards. I said, yeah, well, look at this one. That's me, I won.
Yeah.
That's me, I won. That's me, I won. That's me, I won. So you should show this to them. Don't show it to me.
Yeah.
Look at all the no causes. I'm like, I never got no causes. So.
That's the thing in a conservative county too, is like you say, if you're in a more of a low income county, then the juror might not know the value of $1, whereas in a conservative county, they're like.
Yeah, and you've had that, and the experience where the jury comes back in a conservative county, they award what they think is a lot of money. They're giving you a thumbs up, shaking your hand on the way out, and you're like, can't do much with that.
Well, I used to say when I say conservative county, I equated conservative with well-to-do upper income counties, but the case Mark is talking about there is I tried this case, and like you, I put my heart and soul into these cases. I tried this case in Ocean County. And he was a passenger, and it broke his knee and had a knee replacement. And I think they were offering, I don't mind talking about my losses.
Yeah.
People love talking about their wins, but I think we learn more from our losses than we do from our wins. And I think the insurance company was offering like $220,000 to settle the case. I'm like, are you kidding? It's a leg knee replacement case. And I tried this case in Ocean County, and this was probably like 10 years ago. And they awarded $120,000. And the plaintiff was a salt of the earth Ocean County guy. He was a tugboat driver. He was one of them. They offered him. They awarded $120,000, shaking his hand on the way out like they did him a solid. They just took care of him. And that's what now we're saying. And that was a conservative county, conservative, but not a generally.
Well, they don't no cause you; they low cause.
Low cause.
You know, they. I've had the same thing where I've rejected like $350 on a case and gotten $100,000, and the juries literally gave me the thumbs up when I came out, and I'm thinking, all right, we got him.
Yeah.
You know, they just don't know the value of money, or you know. They don't get to hear about how much money is on the table.
Yeah, and
so they're starting from scratch.
I think being in this business, and sometimes I'll talk to friends, family members, and be like, oh, yeah, you know, to settle this case for this. And they're like, do you have any idea of like the type of numbers you guys talk about? So I had the same thing last year up in Essex. Jury came back. I think they awarded, it was like 140 or something like that with everything. And it was, she broke her arm, had surgery on it, hardware put in there. So same thing. I'm thinking that that's worth a couple multiples of that number. And I've run into a juror in the parking lot, and she's like, "Great, you know, congrats, the same deal." And then you look up, you're like, "All right, well, what's the average income in this area? How much is know living here?" And it's just we live in kind of a different world with the numbers.
Yeah. Plus, I mean, I don't know. I mean, they don't know that you're spending money on this case. When the lawyers got to get paid, the expenses. They're seeing all these doctors come in. I mean, one of my things that I've changed over the years. And it's in that book. If I had the smallest case, could be the smallest policy, I didn't care. If I was trying the case, I was trying it as if it was a $1 million case. I would bring in 11 doctors. If they saw 11 doctors, all 11 doctors were coming in. So I would spend $50,000 on the trial,
Wow.
and then on a 15 policy, and then hit them for $800,000 or $500,000. So I just know you have a much better chance of winning if you do that, and the trial would last like 2.5 weeks. I would be on trial. I would be my case, for like literally 10 days, and then they'd have one day they'd put their defense doctor on, and I would call them Army tanks. I had 11 Army tanks. They had one, and I'd blow them out of the water. So I wanted the jury to think the case was bigger than it was by doing that. I don't think that way anymore, though. Now I think it's the opposite. You want to do a quick. I won't call 11 doctors. I'll call 5. But I'll get them on and off in the hour tops. So I want the case to move rapidly. So that's my the way I'm trying cases now. And to bolster that, I heard on the radio. I was listening to I don't know if it was a podcast or what it was, but it was something about a lawyer tried a case in Philly. It was a seatbelt case where the seatbelt malfunctioned, and the person got ejected from the car. $98 million verdict. The case lasted 3 days. He had, he put on the doctor, he put on the like an expert on life care planning, and that was it. And the client, that was it. And the case was over in 3 days, $98 million. I'm like, you don't need a big giant trial to get giant numbers if the case, if the injury is warranted.
I think we have to meet jurors where they are, and the jurors today, the attention spans with the social media and the swiping, they want it in small bits. And the Lincoln Douglas debates, when they went on for like days because you lived in your little village, there's no TV, no radio, and that was your entertainment, that was your thing. And now, people are in their I feel like I feel like I found, in the law firm world and stuff, where you get employees, and especially the newer generation, like addicted to their phones. Like they cannot put the phone down, and they might take like 15-minute bathroom breaks a day just to be on the phone. And it's like a detox thing. So we got to deal with that with jurors too.
My son, ironically, he's in high school. He goes to high school in Massachusetts, plays hockey. You're not allowed to have a phone from 8 a.m. to 3 p.m. He just started, Labor Day. I got an email. He had 4 violations already of using the phone during the day. I mean, he's addicted to it. It's crazy. Same thing. I hear you. My other kids, you watch a movie. I put on the best movie that, put on Saving Private Ryan, like something great, exciting movie. They cannot watch the whole movie.
Yeah.
They just don't have the attention span.
It's really an issue. I think it's causing a lot of anxiety. We talk about it all the time. But I feel like like AI, artificial intelligence, has just come out, and it's what it does. It's crazy. It just started. Maybe it's been around for a year or two now in earnest. So we're only a year or two into it. Fast forward 50 years, and the stuff that AI is doing, it's ridiculous. Like, you could take a picture of your backyard, upload it to ChatGPT, and say, redesign the landscaping.
Yep.
And it will upload a picture, and they'll say, what kind of plants do you want? Do you want this? And it'll do it. So I feel like there's a little bit of an issue, and we got to deal with this in running law firms and really running the world, where some of these kids are addicted to their phone. They're going to use AI to do their job, and then they're just going to be like androids, like in a phone. Do you understand? Like The Matrix is like a prophetic movie. Mm-hmm. We're going to be in pods. They're going to be plugged into this artificial world. The bots are going to be running things. Like, I fear it might become like that. Anyway, I don't know what this has to do with lawyers and trials, other than those are our jurors that we now have to deal with, which is why a 3-day trial and a $100 million verdict, you don't need to spend, 2 weeks or 2 months now.
Well, that's my thought. I think it's all post-COVID, especially.
Yeah.
What do you mean about like post-COVID?
I just think that, after COVID, a lot of the things, like even Zoom, like I hated, like if I have to argue a motion, I want to be in the courtroom with the judge. Like, I want to argue it in person. After COVID, we did all that via Zoom. I was just so uncomfortable with it. Now I love it. Now I don't want to go to the courtroom if I don't have to. I tried a few Zoom trials during COVID.
Oh, wow.
Which was really bizarro, because I had my conference room set up kind of like you guys have this set up, with cameras and lighting and all kinds of stuff. And you would have this monitor. It would look like the Brady Bunch. You'd literally have 12 people on there, and you'd be talking to a monitor. I just found it so bizarre. And I did 3 or 4 of them. All of them settled, like, throughout, during the trial. And I knew they would. It's just, how some of these carriers, you got to get them into the courtroom to get the case to settle. And that's exactly what happened in those cases. But I did not. That I didn't like. So there were some good things that came out of it, I think. But I think, for example, Zoom, everything. I mean, we haven't met very rarely now do I even meet clients. I do it all on Zoom if I'm doing an intake. A lot of it's done on Zoom. Not so much in person. I did every client. I'm sure you the same thing. Right? Every client I ever signed up for 20 years was in person. And then, the last 5 years, a lot of them are virtual. I'm doing them virtually.
When you say that you have to, the case is going to try it, but the insurance company makes you pick a jury or maybe try it for a couple days, like it's Ed Capozzi. And by the way, just so people know, we have a lawyers group for the Plaintiffs Lawyers Bar, AAJ, American Association of Justice. And every so often, it seems like at some point, it was every month or so, there'd be a post up there that says, Ed Capozzi strikes again, meaning he just got a big verdict in a case that was looked at as a bullshit case by the insurance company, or by their more specifically their picked and paid for doctors. But it's surprising to me that someone like you, with your reputation, like, does the insurance company really need Ed Capozzi to pick a jury to see that he's serious, that he'll actually take a verdict? Like, have you seen an evolution in your career where, when you were just starting out, whatever, but now, see, we have found, and I want to get your story, but we have found, because of verdicts that we've gotten and successes that we've had, that there's an effect that it's not a trickle down, it's more, it evades the firm. So it's easier for a younger lawyer in our office to get more money out of a case, because maybe the successes that Mark and I and Stephanie in our office have had. Have you found that in your career, that you're getting more money, it's easier because of the... Well, tell about that.
When I first started, I worked for another firm. I wasn't a partner there or anything for a very short amount of time, but the only way I would get paid was if I got a verdict. If I settled the case, they wouldn't give me a percentage of it or anything, even if I got the policy at trial. So my thing was, I'm trying every case. I just told them I want the policy or I'm trying the case just so I could get paid. And I literally would try 16 a year. So I would literally be on trial 45 weeks of the year.
Wow.
I won every case for 6 years. So I won literally 100 cases in a row. And then I couldn't get a trial. Like, I went 5 years maybe, so not even trying that many, because they were just paying me on every case. But then I got to the point where I'm like, well, even on cases where they were paying me a ton of money and I should have settled them, I wouldn't settle them. I tell the clients, if I lose, I'll pay you the money. Just don't take the money. I'm going to win this case. I mean, I was crazy. Actually, honestly, I was crazy at the point in time. But that's what I did. Won a lot of them. I didn't have to try as many. I don't have to try that many now. I mean, and I'm a lot wiser now. I'm a lot older now too, because it's 2:00 in the morning and I'm preparing for this case, and I'm saying to myself, "What is wrong with me? I could settle it right now and walk away with $100,000 and everybody gets paid. What is wrong with me? Why am I doing this to myself?"
And I grew up. Listen, I grew up the youngest of 13 kids, and I had something of a rough upbringing. I mean, in a lot of ways, my mother, God rest her soul, loved my mother, but she was hard on me. Okay, she would tell me, she would say shit to me that was not cool. So, and it affects you when you're a young person. So like she would say stuff like that you're not a good person, you're going to be a failure in life, whatever. It's just the truth. So if my family gets pissed at me for saying that, I'm sorry, it's the truth. Okay, and it had an effect on me. So when I became a plaintiff's lawyer, and insurance companies and defense lawyers, basically what they do. The thing is about our job, and you mentioned this, is that because I used to do defense work, I worked for insurance companies for 2 years. When you're an insurance defense lawyer, your boss is going to come to you, drop a file in your desk, and say, "Go defend that case." Right? Try to get as little as money as possible, whatever. And so you have to take these ridiculous positions as a defense lawyer and do whatever you can to deny the insurance company so they don't have to pay money and pay compensation to someone that's deserving of it. But our thing is different. And you said this, you wouldn't take a case that's fraud. We can select our cases, Sure. So we select cases and we believe in the case like you described. And then when the defense lawyer rears their head and starts saying BS about our case, that it's this and that, I get so mad, and my mother comes back in my mind when I was a child, and she would tell me that I'm no good or I'm going to be a failure. And I'll sit here and I'll be writing, and I used to do it especially when I was a younger lawyer. I'd be fighting motions and banging the computer thing, motherfucking defense lawyer, and I would do that. And I think there's something, because I do want to get to your background and stuff, like what makes you tick and what makes you put your heart and soul into these trials. There's something in our DNA or something in our upbringing. Like I had, again, I got to shut up, but I had one trial. I forget if you were there or not, but we were here. We got back from court. We had been on trial a week and a half. We got back from court to the office at about 5:30, and we worked on our closing PowerPoint until about 5:30 the next morning. There was 4 of us in my office over here. My dog was here, and my dog kept looking up at me like, "When the hell are we going home?" And like you just said, I'm like, why the hell am I? There's something in our DNA about this, and our.
Yeah, I mean, I only had 3 brothers and sisters, so it was 4 of us. But my father worked; he was an electrician. We grew up very modestly. My mother didn't drive. We had 1 car, 4 of us. I would go to baseball practice on my bicycle with my bat and glove on my shoulder. I think about I compare that to today, where I have multiple kids. I got to take to this practice and that practice. If I wasn't there, my father was never around because he had 3 jobs, so he worked all the time. So I had to get to my practices on my own. If he got to see one of my games, it was a very, very rare occurrence. If I asked him for 25 cents for the ice cream man, he'd say, "You better get out of here." We didn't have
backhand you.
Yeah. If I disrespected one of my sisters, I was the youngest, so we're at the kitchen table and they would be teasing me, and I'd say, "Shut up," and he'd smack me right off the table.
My dad had a plastic bat.
Yeah. So but doesn't mean that. I mean, I loved my father passed away, but I loved him. I mean, I respected him because he was a man's man. He was a hardworking guy, the nicest guy in the world. But if you ever got him mad, he would, crazy. But and I had paper route. I didn't have anything, so I had a paper route. When I was 8 years old, I had the Daily News in the morning. I grew up in Long Island, so I would deliver papers before school. 6 in the morning, it's raining, snowing. I'm on my bicycle. The papers are falling over, blowing all down the street. Then after school, I had another paper route, so Long Island Press, it was called, and that was delivered in the afternoon. So after school, I would do that, and in the middle of it, play all the sports and do everything I did. But if I wanted anything, I had to work for it, and I had a lot of little jobs. growing up, like all these blue collar jobs. So when you come from nothing, you can, I really appreciate where I am now. Even as I got older, I was a sanitation worker. I was a landscaper. I mean, a carpenter, a tile setter.
Wait a sec. Sanitation worker or garbage man?
Garbage man. I was a garbage man.
See, you're saying
respect,
the words that work. Words
Yeah.
that work.
Yeah.
Sanitation worker, not garbage man.
Yeah, it was garbage man. So I did that for 2 years. But then after that, and I was 20, 21 years old, I would run the entire route behind the truck because I was in shape, But I've done the dirtiest jobs of the dirtiest. I've had the worst jobs. A tile setter is bad too,
Yeah, being
doing
on
mud
the
jobs and laying marble and tile and cutting it in the winter and carrying buckets of cement upstairs. I mean, I've done it all. So, I can relate to a blue collar person. I'm actually more of a blue collar person than a white collar person. But, I can hang with lawyers. I can hang with, musicians. I can hang with garbage men. I'm like a chameleon.
Where do you think it comes from that you're working so hard like that, putting your heart and soul into it? What makes you tick behind all that?
And I say this to everybody, the best lawyers I know were all athletes. They played, I played football, I played baseball, I played hockey. And they are. You want to kill each other literally in that courtroom. You want to kill each other. I'm very competitive, So that's my take on it. Do you guys agree with that?
Oh yeah, it's funny. I'm sitting here cracking up because it's totally true. Like Jerry Rose, I'm not going to give his age, but he's out there with guys in their 20s. He's lapping them like we've played pickup basketball together. I think he's thrown some elbows around and stuff. But you're
bullshit. You fouled me, Mark.
Yeah, exactly. I didn't say you elbowed me, but you're totally right because that's the best thing I can compare it to when you're in a courtroom is like you feel like you're going into a sporting event against somebody.
Yeah, and they used to piss. I mean, some of these lawyers piss me off. I tell them, I'm going to kick your ass in this courtroom, and when it's over, I'm going to kick your ass outside too. I mean, I've literally said that. I don't do that anymore. I'm much calmer now.
It was another reversal that said you can't do that.
Yeah.
No, I'm just kidding.
You said something about whether you talk to adjusters or not when I talked to you.
I do not talk to adjusters. In fact,
Tell the peeps out there what are the adjusters and what does this all mean?
I guess the adjusters most of them are, I could tell they're young, unless they're one of these, older ones that have been with, Allstate for 25 years, but some of them are really young.
Yeah.
And they tell me, we don't think it vaults the verbal threshold. And I was like, oh, really? What medical school did you go to? And then they say, I didn't go to medical school. I said, I know you didn't. And then they start talking legal stuff. I said, what law school did you go to? I didn't go to any school. I said, I'll tell you what. Why don't you come to the trial, and when the trial's over, you're going to watch your money go right out the window, and then you're going to get fired. That's what I would say to them. And then I got to the point, they would piss me off. I would be having the nicest day, and I have a really, case that I know the client. I've been, spending a lot of time with this client, and I'm trying to get them as much money as I can. And then I get a phone call from an adjuster saying, we have $21,000 on. I'm like, $21,000?
Yes.
You nuts?
Yeah.
I said, don't ever call me back again.
Yeah.
And make sure you're in that courtroom when the case goes.
Yeah.
'Cause you're getting fired after this case. But now I don't even talk to them at all. I will not talk to them at all.
I don't either.
Yeah,
I can't remember the last time I talked to an adjuster.
we have like I won't tell our like secret sauce, but yeah, it's just it's almost pointless. But the majority of the time, it's pointless. They're going to tell you how much your case sucks. They're going to tell you all the things that's wrong with it, and it's just.
Well, I mean, some of the stuff they say is just. I had a woman whose leg got amputated. Right.
Yeah.
They said she had a great recovery. I said, "Are you out of your mind? What do you mean she had a great recovery? She's got no leg. She's never going to have a leg. So there is no recovery from this." I said, "Are you nuts?" I mean, that kind of stuff it infuriates me, and it makes me want to, beat them more.
What I have found is that settling cases is a big psychological game. It's a real mind, and like if you think you're going to settle a case, like I love the phrase, you can always settle a case you're prepared to try, but you can't try a case you're prepared to settle. And I find the best way to settle cases is to prepare them for trial and ignore the adjuster. And they almost are begging for me to give them a demand or begging for me to go to mediation because I'm like, no. And I have found that settlement, you could have, some lawyers walk around the courthouse and with a cup, like, come on, what can you get me in this case? Like they're like begging for nickels. Like You don't do that. We don't do that. But I find that a lot of insurance companies and the defense lawyers use settlement as a distraction, where you're trying to prepare the case for trial and they're trying to take you off the game.
I hate that.
So what I do is, if I think they're serious, I will bring in a second lawyer, or usually we pretty much, we try the bigger cases, we always have at least 2 lawyers on the trial, usually 4 working on it, but 2 in the court. So we'll put the second chair, we'll talk to the adjuster, and the first chair will continually prepping the trial. I won't even talk to him about settlement.
I agree 100%. I mean, because what happens is,
as
soon as they start offering you a little bit of money, you think, oh, the case is going to settle.
And
you let your guard down.
And then
100%.
you let your guard down and rest. I was at one trial. We were at one trial in Hudson County, and our team was there. We had a bunch of people, and I was up. I don't know how long. So they had. In Hudson County, they have an old bank vault in the back of the courtroom, which was our war room. It was awesome. It wasn't the jury room. And I was literally there during deliberations where the jury's deciding the case. I'm sleeping in my suit there. And they're like, Jerry, they just offered $2 million. I said, talk to Don and tell him, we'll reduce the demand to 6, literally as I'm sleeping. And they went back and it was like
I know how you feel.
Like, you got to separate that settlement from the war. If you think that,
But you got to prepare it. Every case, we prepare it for trial.
We don't. Same thing. Yeah, so the trial that I'm on now, it's a very experienced defense attorney, and we go to sit down with the judge, basically come up with a preliminary statement. And we're sitting there, and he goes, what number would you take to settle this case? And I know there are no, it's just, I let it go in one ear out the other, because it's almost like you're at war. And someone's saying, all right, we're going to pull you off the front lines. Like, all you have to do is just, compromise. And it's so tempting. And if you feed into that, it's such a psychological thing. So I think it's great that we do that.
Well, it was my most recent trial. So the case was it was a boating accident, but the case was worth, $300,000-$400,000. They only offered me $100,000, so I wasn't taking it. And we went Monday for the trial call. And we sat around all day on Monday, just trying to settle the case. So they finally said, "Will you take $150?" And my clients finally just said, "Let's just get it over with." So they offered them $150, and they said, "Okay, we'll have it tomorrow. I just got to get approval." It was an experienced guy. So I went home. I didn't prepare at all. Come in the next day. He says, "I don't have it. I have 118." I said, "What?" Next judge is like, "Well, because let's pick a jury now." I'm like, "Judge, I'm not even ready. I mean, I could pick a jury, but I can't open or anything. Give me till tomorrow at least." So we did that, and I hit him for $950,000.
Good for you.
And they appealed it, of course, and they offered me the $150. I said, you would have taken it then. I said, yeah, I would have taken it before I had to try the entire case. Put my clients through this. It's unbelievable.
Don't you hate like that aspect of it, where it's like, if I get you this, will you take it? And you go and you say, yep, and then they come back like, we don't have it. I got burned on that this summer, and I haven't had that happen to me since I started my career 10 plus years ago.
But we see some of these cases. I mean, we unfortunately, it's like sometimes I make the mistake of, I see it. I'm a plaintiff's lawyer, so I only see it. I have my blinders on. I'm like, I'm going to win this case. Then I'll lose the case. And then when I go home, I'm driving home. I always say the day a verdict's going to come, I'm leaving my car, and I'm like, I'm either going to come back to this car the happiest guy in the world, or I'm going to be pissed off. Well, this particular day I was pissed off. I came back to the car I had lost. And then when I drove home, I thought about it. I said, you know what? At the end of the day, they probably made the right choice. I mean, I was so blinded that.
And that's the conundrum that we're in, because you have to be in war mode, but you also have to have your antennas up to settle the case, because you have a duty to the client. And I've never said, if I lose the case, I'll pay the verdict instead. I'll pay what it's worth. But it's a crazy business we're in, where you have to have those blinders, but you also have to have the antennas up. And if you don't believe your case, the jury can see through that.
Yeah. It's like, you have to be yourself. I mean, that's what, if I could say, I do a lot of seminars, and I always tell like young lawyers, I wanted to be Mike Maggiano, when I first became a lawyer, but I was nothing like Mike Maggiano, so I had to be myself. And, you read all these books. I said, just write your own book. You got to write your own book.
Which you literally have done.
Yeah, which is a hard thing to do, man. I got to tell you, writing a book is tough. Because of the editing process, I could have wrote that book 100 times. Wow. Going back and forth, it's very difficult.
when I read the books and started using the books, and my assistant was Tanya, and she knew me really well, and she's like, yeah, like it seems good, but you're just not yourself. She's like, you got to be yourself, and you know, a lot of these books, your book is written Jersey centric, but like Rules and Reptile is a lot of Georgia and Washington State, you know, and there's different cultures there, and they try things differently. But I think the way with the books is you want to do it, but incorporate it into yourself. You have to be yourself.
And I steal a lot of things, Jerry
Spence or whatever.
Friedman,
Rick Friedman.
Spence, even TV movies, Few Good Men. I mean, I steal everything I can from every movie.
I'll be for trials often. I did this. I've probably listened to about 8 Andy Fraser trials. When he gets a verdict, I will order the audio. I'll listen to it. And what's great about him is he has molded kind of Rules and Reptile into the Jersey way, compliance with the Jersey. So it's really helpful.
Yeah, he does a good job on the time unit rule.
Yeah, big time.
And that's another thing. There are trials. Well, I will not do the time unit rule only because I'm barely going to win this trial. I don't want to push him over the edge by breaking it down into millions of seconds and stuff like that. So I'll purposely will not use it. But there are other cases where I do. Obviously, I do use it.
But the people out there, they should know, again, at least in my view, and the cases I pick, and I'm sure you pick, it's like these are good cases. They're legit people. But you're right. Like sometimes you leave, I lost. You know what? The jury might have made the right decision in that one. So that happens too.
Yeah, I mean, one case I lost in federal court in Camden. This guy fell off at the Borgata, I think it was. There was that round room in the middle of the casino, and he climbed up on this ledge. They were taking a picture. In fact, the bartender, one of the barmaids or waitresses said, get in the picture, get up on the top of the couch. And he sat on top of the ledge thinking there was a window there because it had curtains and everything. He leaned back. He went over the side. And I thought I did a great job on the trial. I thought I was going to win. But the defense attorney was a really good lawyer. And he said, what's the first thing they teach you as a kid? Don't climb on the furniture. I said, oh, man. In his closing, he did. I said, oh, God, I just lost this case. And I lost.
Wow.
And then, like I said, driving home, I was upset because I bring a couple lawyers with me also to all the trials. I have like a second chair, sometimes a third chair, just to do a lot of the research that's going on the fly.
Yeah.
They're like, oh, you killed him, you're going to win, and then
You can't have an echo chamber.
No way.
and I lost, and I'll never listen to them again, kind of thing. But
I took my dog for a walk last night, and another attorney in the office who's been working on the case I'm on trial on had called me, and I was like, I'll get back to him, see what's up. And we talked for a while, and he's like, he's telling me all the good things about my case. I'm like, dude, you got no idea. You never know what a jury's going to do. Like, they've got,
We'll bring an assistant, too, who's not a direct employee of the firm a lot of times to be like a shadow juror and tell this, you can't have yes men around you or yes people, yes women. But I just want to go back to, because I think it's important for people to know this, and this is good too. And I might have told this before. So like I wrote an article up there about there's no such thing as an IME in New Jersey injury litigation. For years the defense bar has gotten away with putting IME in the lexicon, calling a picked and paid defense doctor, like Mark just described in his trial that he's on now, that's done 100% defense. You have 18,000 reports from some of these doctors that are hired by the insurance company where they've never found anyone injured. And for years, these doctors and these exams have been called independent medical doctors and independent medical examinations, which is the craziest thing because they're the farthest thing from independent. They're picked and paid by the insurance company. They're incentivized if they find... Dorothy Clay Sims writes that book. I'm sure you've probably done seminars with her.
I have exposing deceptive defense. I do the exposing deceptive defense seminar with her for years. She doesn't really get involved anymore, but not that she wouldn't. But I've done a ton of.
But one that jumped out at me from her book is like they said, how many times can you write a report and find that they're actually injured and it's legit before these insurance companies will hire you again? And it was like 0. Like they couldn't. If they did that, they wouldn't get any more business. And what happens is, Dorothy Sims writes in that book that it's a lot easier to be a defense medical examiner than battle medical insurance companies actually treating patients and all that stuff.
They don't have any patient, doctor-patient relationship, so they're not liable. We ask for, one of the things we ask for, in every case we have, I'm not sure if it's in this book, it might be, but we have the supplemental notice to produce for them to produce every report they've written where they've caused a related an injury, which they never provide any.
It's in the book.
Yeah.
I think I have it flagged and highlighted the page.
Yeah, so they never provide any. I want their medical malpractice insurance. I want the policy, the application, not the policy. The application, they ask what percentage of your work is defense medical exams. They don't want to pay a big premium, so they write 100%. Then they say, oh, my practice is 50-50, 50% I treat patients, 50% I do DMEs. I said, really? Then why'd you tell your insurance company you've committed fraud right now?
That's funny.
That's a good. They fight you on that to give you that as well. So I make them jump through hoops. I have some of these. I take their depositions, and what I do, I set them up. So after I ask for all that stuff, I take the dep, and then I said to them, how many reports did you write? And I have it. If they work for a company like ExamWorks, for example, I have the vouchers that show every exam they've done, every deposition they've done, every trial testimony they've done, supplemental reports, record review. I have every single item on this thing. There's thousands of entries. So when I ask them, how many reports do you write? Oh, I don't know, about probably, 5 a week or whatever. I said, well, you did 9, I know last year you did, 1,437. Does that sound right? Oh, yeah, that sounds about right. I'll say, so out of the 1,437 reports you wrote, how many people did you actually find injured? And they would say, oh, probably 25%. I said, all right, so if I got every one of those reports, we could actually check and see if this is accurate, right, your information. Yeah. So would you mind if I actually asked for these reports? Like, would you object to it? And the guy's like, not really. And then the defense attorney's objecting, and ultimately then I subpoena the reports. So if I have the deposition, sometimes the judges, some judges are favorable and they give them to me, and I get every single report. And then I could literally read them all and say, all right, out of these 1,400, you found 0 people injured. Even people with broken femurs. Yeah. They said they have osteoporosis, and they were bound to have a fractured femur anyway. I mean, it's ridiculous. So, but because of that Jen Solin case, you guys familiar with Jen Solin?
That one I'm not.
Jen Solin is the case that says, you can't make the defense expert like cry uncle, which is what I try to do. As long as they show some bias, then that you have to cut it off. It's GENSOLLEN. Defense cited every time when I try to get the reports. The difference between Jen Solin and any doctor that works for ExamWorks or one of these defense medical exam companies is that was he didn't work for a company. He was a private orthopedic surgeon. So they said it was so burdensome for him to produce every report that he didn't have to do it. So what I do when I argued the case, I said, yeah, well, with this particular company, and here's how many times I've gotten them. If I get to this voucher, it'll say page 1 of 437. So I know that they're all there. It's easy to obtain.
Yeah, it's a click of
all they got to do
mouse.
is press print, and I have all the guys' information. So that's how they fight me on it. But sometimes the judges give it to me, and when they do, then I keep doing it until a judge does give it to me. And now I have pretty much every doctor's I know exactly what they make because I know not only what say for example ExamWorks charges, but what they actually pay the actual doctor at both registers.
So these doctors they could do 20 exams a day, 25 exams a day. By the time they get to trial, maybe 2 years after they did the exam, they don't know from Adam the person. So I've heard, and I don't know if it's necessarily true, that and that these defense medical. So what happens out there for the folks at home is the insurance company will hire a consulting firm that will organize the defense medical exam and get the doctor and all that, and then they'll print it, and so all the doctors. And I've heard from other lawyers that they believe that sometimes the defense medical exam company will then tinker with the report, will change stuff in the report. I've heard that. I don't know if it's true, but it wouldn't surprise me because and the doctor's not going to remember, and he's not keeping the thing. He's just ExamWorks has or the company has the report.
One of the beauties of getting this actual document, this register, whether it's a voucher register or an invoice register, they're called, it shows every event that the doctor actually did for that company. So on a certain day, you could find your own client on there, and he'll have done 20 that day, 20 exams, and he'll say, "Oh, how long did it take?" "Oh, it took me 2.5 hours." I'm like, you saw 19 other people that day. You reviewed the films, you reviewed all these records, you wrote the report. I said, come on. They're not doing that. They have paralegals or secretaries that are tabbing all of the records. They're entering the information, all the negative stuff. They're cherry picking all the bad stuff for us.
Yep.
They're putting it in there. They're guys dictating maybe 30 seconds worth of information that goes in there, and then he's not even signing it.
It's a template.
It's a template.
And they were doing that in 2008 with the market crash and all the foreclosures on the homes, where there was stuff where these foreclosure companies were just signing affidavits to do all the things, and that came out. So that kind of automated stuff can happen.
Yeah, plus there's also, you should be asking for this. The transmittal letter that goes to the doctors, to the to doctor's office from a company like ExamWorks, and it tells them what to do, like what to look for. To don't look for alternative diagnoses. Look about pre-existing. I mean, they suggest everything. Yeah. They put all the some of them are wild. They put in like the facts. They had a prior accident. They had this. They had that. With a very small impact. They have all this information in there.
So we had a trial. We had a trial called Fernandez some years ago, and we were in Essex County, and Dr. Dector. What's Dr. Dector's first name? Edward Dector. So everything I'm saying here is factual, and it's in a transcript. Where
I like Dr. Dector. Actually, we became friends after I crossed him in Essex once.
Yeah.
He's not a bad guy.
Yeah, I'm sure he's not a bad guy. But he was at trial in a case, and it was a fractured pelvis where a trench collapsed on a worker. And after my cross-examination consisted of, it was all about ExamWorks. And it showed that he had substantial stock in ExamWorks, and we were able to establish that an ExamWorks had arranged the exam in this case. And we said, well, and we got the website from ExamWorks. They probably cleaned it up by now, and ExamWorks talks about what they do and how they support their clients, and the clients are the insurance companies. And I was able to walk through and show that ExamWorks' incentive is to find that the plaintiff is not injured or minimize their injuries, and the better they serve their clients, the better the company does. And I said, Dr. Dector, you have stock in the company, don't you? He owned like $23 million worth of ExamWorks, something like that. Then I think the transcript says something like he denied it, and I was able to hit with the 10Q that shows his wife owned the thing, and then redirect. And then the defense lawyer tries to rehabilitate him on redirect. And, they say at trial when you're cross-examining a doctor, again, this is the books, you probably do the opposite and get a big verdict doing it. And I used to think when I was a young lawyer and I would cross-examine the doctor that I would swipe him, shred him, make him look stupid. And Rick Freeman writes in a book, he goes, it feels good, but it's almost always a mistake to do that, to really rip them to shreds and make them look bad and all that stuff, unless the jury wants you to, okay? And if you get to a certain point in the case, and you can, because you can read a room and you can read the energy in a courtroom, and I felt like that was one of the times where the jury was so pissed off at what they saw about what was going on and the money behind the bullshit of the defense exam. I said, this is one of the times. So after he redirected him, he goes, Doctor, you look on the film, and the film, it doesn't show the injury. And that's right, defense attorney, it doesn't show the injury. So I did a redirect. I said, Doctor, you said there's no injury on the film. That's right. I said, you have 23 million reasons to say that, don't you? And it didn't matter what he said. He stormed off the stand, all pissed off, and it's just like, we're just exposing bullshit, and...
Well, like I said, that case kind of says if you can't have the defense doctor cry uncle, like if you show bias, that's all you get. You're not allowed to pound them into the dirt
That's
with
fine.
some of this information.
So when they show the plaintiff is incredible on one little thing, do we get to stop it there and say we showed they're incredible and you can't let the plaintiff cry uncle? I mean,
it's disturbing. Like why they would defend these people. I mean, it's so hideous.
Yeah.
Well, they're saying, well, it has a cooling effect on the industry. If doctors are going to get beat up like that and be exposed, then nobody's going to want to be an expert. I said, well, if you told the truth, you wouldn't have to worry about it.
The trials are about the truth. So that article that I wrote, so we started sending nurses to exams like in 2010. We pretty much send a nurse or a third-party observer to every single defense medical exam, and we learned a trend. First of all, if they're doing 20 exams a day, and we're the one or two only law firm sending a nurse, a lot of times they'll throw in the towel. And we found that the defense reports started actually being more truthful. But what we also found is that, so in every single case, and this is what I find, okay, people come to these real bad injuries and like the liability is simple, like a rear end crash, and be like, well, what do I need you for? I said, because they're going to claim you're faking your injury and minimize your injury, and that's where the fight is in the case. Okay, so in every single case, the insurance company, and you can't tell the jury there's an insurance company, but they do it through the defense lawyer. In every single case I've seen, not every single, but infrequently, they're trying to minimize the injury, suggest it didn't happen, and they're almost always suggesting the plaintiff is somehow lying or exaggerating. That I can say in almost every case. They'll never come out and say it. They always suggest it. But what I found by sending a nurse to these exams is that more often than not, in my experience and in my opinion, it's the defense doctor that's faking the exam. And we have found that. Yeah. So what happens is you'll have a shoulder injury, right? And they do it when they have the report. They have the physical exam section, and that's the biggest thing where the doctor will fake the exam. So they will say, "Okay, move your head to the up like this and down to the bottom." The plaintiff moved their head all the way up, down to the bottom, full range of motion, no pain. We started sending the nurses to there, and they would be like, "Yeah, he could only go this high," and he would grimace in pain. And we had it where, a shoulder injury, raise your arms up and down to the sky. And we started seeing that they're actually lying and faking the defense exam. Yeah. And I don't know if it's the doctor that's doing it or it's being inserted by the whatever arranged company they're doing. But these are the types of things that we've seen out there too.
I was always on the fence about that. So I had the opposite. And you and I actually talked about this on the phone last week. And I might do what you're doing.
You don't need a full-on nurse. It can be anyone, and you got to just videotape it.
Witness,
yeah,
right?
Exactly.
Are they videotaping it now?
Yeah, now we videotape them all.
Post Fiore,
and they would oppose it in the case. I'm like, I'm sorry, but like cops need body cams. You can't go anywhere without being on video now. But somehow these defense doctors should not have such a consequential thing. And the Fiore case, which is the Supreme Court case, the language of that article there, which I published during the pendency of Fiore to get it out there, is in the language of the Supreme Court opinion about that cameras are ubiquitous today, and they don't necessarily like that article is like, no, it's bullshit. They fake the exams.
Because what worried me about that was that the doctor would then be more thorough in those particular cases. But you're saying the opposite. You're saying they're just throwing the towel on those because the rest of them they could just do any way they want.
Yeah, but who cares if the doctor's thorough? It's if the plaintiff is injured and it's legit, thorough.
I know, but I just thought, I know.
Because you love saying that, hey, you spent 5 minutes with them.
5 seconds, 30 seconds. We have, what I do is every once in a while I'll have the client just turn their phone on and record it. And then what they say to them and what they actually do is ridiculous. And literally 90 seconds, the exam's over.
Yeah.
I've done that.
Again, I have 1/1000th of the war stories that you guys have. But I do have one of the recording thing like that. I had a DME doctor, defense medical doctor. My client recorded it. He goes, look, I don't have your films. I don't have your medical records. Without those things, I can't give an opinion as to what your injuries are in this case.
Oh, that's good.
Then lo and behold, he writes a report where he gives an opinion on her injuries in the case. And he says, oh, yeah, she's fine. It's not that bad. At trial, I play the audio. I say, doctor, do you remember saying to my client that you couldn't give her an opinion onto her injury about her injuries? She had no films, no records. He goes, no, I never said that. Press play, and he's like, I couldn't really hear it. Could you play it again? Sure, play it again. The same thing. He's like, yeah, I guess I don't recall saying that, but that is me. And then lo and behold, he gives an opinion. So it's definitely really helpful.
Again, I don't know if that's the doctor, though, or I suspect the company that is arranging the exam and typing the report may change it. And I'm not saying any particular company, but
I love when they don't review the films and they give an opinion, then they have a supplemental report, with the film read on it. I mean, you have a puzzle and you're deciding the puzzle before you have the biggest piece of the puzzle.
Yeah.
Hey,
let's take a quick break. Hey, so although what we're doing is, it's a very noble profession and all that. At the end of the day, it's a business. The law business. It's a business. Unless we all have red crosses on our arms, it's a business, and we have to keep the lights on. We have families to support. We have staff to support, and most importantly, we have clients that rely on us. And in order to be able to properly represent those clients, we need to be economically stable. So, given that, lawyer is a business, plaintiff's lawyers is a business, I've seen in my experience there's different business models. Just like there's different restaurant models. You could be America's largest restaurant. I don't know if it's McDonald's or something, but I wouldn't necessarily want to get a hamburger from McDonald's. I probably want to get one from more of a boutique, nice steakhouse, and we can have America's largest law firm, per injury law firm or whatever. Have you seen anything in terms of the business model? As lawyers, we can only handle so many cases. You can only be on trial at one at a time. What kind of business model, have you guys incorporated? Are you guys on billboards? Are you taking in thousands of cases and getting whatever you can from them? Or do you put more TLC into each case to try to maximize the recovery for each client?
Well, first of all, with regard to billboards, we don't do any advertising whatsoever. I mean, most of my clients are either, and I get referrals from actually judges. I get them from defense attorneys. I get them from prior clients, that were happy with the service. So, we don't do any of this mass advertising. I'd rather have less cases and get bigger rewards or awards on those less cases. I know, believe me, I see these billboards and they make me sick to my stomach, because I'm driving down the highway and it's a billboard, another billboard, another billboard, and it's the same firms doing it. And, the firm, I think we all know who you're talking about with the largest law firm. I mean, they're not even from New Jersey, okay? They first came to New Jersey recently. They were referring me actually all their work in New Jersey for a while. Then they took a few lawyers from New Jersey once they had enough cases, and they actually started doing work in New Jersey. But, when I see their billboards, I almost laugh to myself. I'm watching a Yankee game. I see them around the Yankee Stadium. They're on the walls of the stadium. And then I go to Boston. They're on the walls of the Boston bullpen. It's like, they're pro Yankees and they're pro Boston up there. I mean, it's the worst, one of the biggest rivalries in the world. I mean, it makes no sense to me. And I think it amazes me that they spend money that we can't compete with because they are a big law firm. But you would think the opposite, that you're just a number there. And, I know a lot of people that work there, and I know some of the bigger people that work there. They do have some very good lawyers, but they're not going to be the one trying your case in New Jersey, that's for sure.
Yeah.
And this was, I think, the best thing that ever happened to me by not, advertising. In one of my last trials I had, and this comes up when you're jury selection also. The jury said that, when they were asking them, do you think, people are too litigious?
Yeah.
And they say, yes, they're too litigious. They sue over anything. You see these law firms on these billboards promising you all this money, and I said to myself, wow, that's an interesting thought. So, now, post 9/11, not 9/11, post George Floyd,
yeah.
COVID, they have a new jury charge that talks about unconscious biases, about being racially or religious biases. And when I did my closing in that case, where the people were talking, a lot of them, it wasn't just one, it was several of them were talking about the billboards and how it turned them off.
Yeah.
And I said in my closing, you were instructed by the judge about unconscious biases, about being, biased both because of religion or ethnicity. I said, but you're also talked about. You also were instructed on conscious biases, which are like the law firms on the billboards, which you saw. I said, and I want you to know, it makes me sick to my stomach when I see these signs that it cheapens my profession. It's bad for my client. It's unfair to them that they're being, put into this pool of people that they think are frauds. And I said, and I could tell you something, I don't have a billboard, and I don't need a billboard. You know why? Because I'm a real lawyer, and I won that case. But I felt good about saying it. And when people approach me about billboards, oh, you want to be on the billboard? I'm like, I'll never be able to say that again if I do it. So I'm not going to do it. I have enough. I don't need to be a billionaire. I have plenty of money that I'm comfortable where I'm at. I have just enough cases that I can employ a bunch of people. But every one of those cases is a good case,
Right.
a real case.
And you're going to put the time it takes into them.
Yes. So I'm very anti-billboard.
It's a volume practice. It's a volume game. Like McDonald's, we make a crap load of hamburgers. We sell them for cheap, but we make money profitable that way. Whereas a steakhouse, it costs money, but it's a really good hamburger.
Yes, exactly. And, I know a lot of people do it the other way, too. They never reject a case.
Right.
Oh, we can get $1,000. Number one, you're gonna wait. You'll have your employees wasting their time on those cases that are, number one, I'm not comfortable handling them to begin with.
Yeah.
Somebody comes in, they have 5 accidents, 5 prior accidents. I'm like, you're either the most unluckiest person in the world, or you're a fraud.
Yeah.
So I don't feel comfortable handling those cases. I don't handle those cases, and that's just the way we operate. I mean, I know there's a lot of different formulas, but that's the way I operate.
Yeah, there's different ways to skin a cat, but we're very similar to that. Like, we reject far more cases than we accept. We take a very small percentage, but we put so much work into each case. I was listening to the Yankee game the other day, and I heard this ad. This ad comes on. And it's like, I'm the Bulldog lawyer, and I'm going to get you.
Yep.
And then the client comes on and says, yeah, I went to the Bulldog, and I got $4 million, and now I can sit in my pool and kick my feet up, and I don't have to work anymore. And I'm like, what the fuck? What is this guy doing? Like, I guess that says, okay, well, I'm going to call this guy to get money. But what it does is it cheapens the profession, and we're here for something deep. Like, the people that come to us, like, they're hurt and they need it, and it's.
Plus, there's another commercial out there where it says, "I got $4 million from so and so got $4 million from me." Another guy, so and so got $2.9 million. I'm like, the happiest people I ever met that got $4 million in awards. Nobody would want to trade places with them. The people, you're missing legs, you're missing arms. They're the most unhappy people in the world. Yet these people sound so happy. Not one of my clients who ever received millions of dollars would trade places and go back and to give that money back to be where they were before.
100%.
I mean, it is to hear them so happy, yelling that they made all this money it's disturbing to me.
We say that all the time. Same thing. No client that would trade the money for the injury.
Yeah. Why would you? I mean, to get that kind of money, you need to be very, very seriously injured, and nobody would trade places.
Yeah, and I was driving in Florida recently, and the billboards in Florida, and like with the money signs and stuff, it's, what the hell is that? What profession are we in?
Well, I mean, Florida, Vegas, I mean, those are places that are notorious for these billboards. New Jersey never really had them, but they do now, and they're everywhere. And some are, I guess, as tasteful as they could be, and some aren't.
Yeah. So tell us a little bit about your background. You did talk about growing up, blue collar. You seem to have a real street sense, and it's funny sometimes. We've had Mark and I have had trials and cases where we're going up against these big white shoe law firms and like these super smart kids that went to Ivy Leagues, and here we are. Like, where'd you go to law school? Rutgers.
That's how I ended up in New Jersey.
Where'd you go to
Rutgers,
high school and college?
I went to Penn State College undergrad.
Son went there.
Yeah, and high school, I grew up in Long Island. I went to Oceanside High School, which is on the South Shore.
Yeah.
Long Beach, Jones Beach, that area.
And you had your paper out and stuff. And like, it's funny sometimes we'll be in court, and we'll be up against like, I always thought, like, when I was in law school, I thought, like, I remember I was taking trial advocacy class, and I said, well, wherefore and therefore, and the lawyer that was treating the trial advocacy was a real lawyer. He was like an adjunct, and he was a real trial lawyer. He was like one of the top New York trial lawyers. I went to Fordham Law School, and he's like, Mr. Clark, he's like, do you talk like that normally? I'm like, well, no, but he's like, well, like, this is trial. You have to talk like a person. Don't talk like a lawyer. And I think I get the impression from you that your street sense, you know, that it translates to talking to people, you know.
Well, I'll tell you that. So 2 things. I was always a very smart kid, and like in school, you know, I did the minimum amount of studying and got A's on everything. When I went to law school, it was like an awakening because everybody in the class was smart. Like, oh my God, these people are so smart. But once we had to do like oral argument against each other, I was beating these people into the ground because none of them, you know, first of all, I was like 10 years older than them. And I had lived in Manhattan on my own, you know, like for 10 years at that point. I lived in California. I've lived in Southeast Asia for a little while. I mean, I lived everywhere. So I had so much more world experience that I would beat them into the ground on oral argument stuff. So, but when I started working, I was working for the Gloucester County Public Defender's Office. And there was a lawyer who worked there. At the time, I was, you know, when you're a certified attorney, I'm still in law school, but I've taken ethics and evidence, so you could actually work somewhere. And you could work for the prosecutor's office or the public defender. So I worked for the public defender. And I would have to go in and argue motions. And there were lawyers in there saying, Your Honor, Rule 407B3 says he can do this and he can do that. And then there was another lawyer who said, Your Honor, he's a good guy. You know, I talked to the guy. He was really down to earth. And me and him became very good, like really good friends. And he taught me how to be myself in a courtroom. And I would win. I think at the time I was 37-0, you know, arguing these bail motions saying, I talked to the family and he's a good kid. He needs another chance. The evidence is weak, you know. Just like passionately arguing on behalf of the person, but talking like a normal person, like I would talk right now.
Yeah.
And I was successful. So that's one of the things that made me, I think, successful in court was this. His name was Seth Belson. He was a really good guy. He passed away actually a few years back, but just a great guy. Changed my life as far as being a lawyer, you know, just being myself in a courtroom. So he was very important to my development. But I think it's important. Number one, you have to be yourself. But yeah. But again, you know, with the people that go to law school, are very smart. I mean, they're smart as hell. Like I could sit in the office. There's, you know, lawyers. 95% of lawyers just sit in an office and never go to court.
Yeah.
I could never do that. That's just like that's not my thing. And they could never go to court and do what I do, and I couldn't do what they do, and that's why we do 2 different things.
See, what fascinates me about this podcast and bringing people on like, you know, Justice Albin, you know, Chris Blastell and yourself is I always try to feel like, how did this guy get to where he is? You know, you've attained, you know, such a high thing in our profession. And like, what is it? You know, did he grow up with a silver spoon in his mouth? Was it this? And what I'm seeing from you is that you have a super dangerous combination of street smarts, having lived it, having to work for it, and like a genetic intelligence. And combining those two, because often if someone's got like a real genetic intelligence and they apply themselves and get really good grades and high test scores, they're going to go to the top law firms where they work, you know, where they're making a crap load of money right away and chase that kind of golden thing. But you're like a dangerous combination.
Well, you know, something we haven't talked about. So I was a musician for 20 years. So, and one of the things that I first did, you'll see it in my book. I hand draw every exhibit that I use in court. I can draw the body, the anatomy of the body better than
I got your diagnosis chart highlighted and flagged.
Painting and drawing since I was like 4 or 5 years old.
Wow.
So and then it
is.
Yeah.
I got your diagnosis chart.
Well, that's a simple one, but
if you don't mind, I blow this up, and I've used it in my last 4 trials. That very thing right there.
That's awesome. I mean that makes it all worthwhile, you know. But because I was more of a creative person, I don't think like a typical lawyer. So, for example, when I worked for this big white shoe law firm when I first started. I mentioned before in Philadelphia, we would sit along this conference room table. It was a mile long, be like 50 lawyers sitting there. And I had just become a lawyer. I'm sitting there on my you're not allowed to put anything on the table without a mat and everything. And they'd say, oh, we have this issue, and they would talk about a fact pattern, and I'd say, why don't we just do this? And they'd be like, oh my God, how did you think of that? I'm like, really? None of you thought of that? I mean, it was the first thing I thought of. So I didn't think anybody thought, whether it's the left side of your brain or the right side of your brain. But I don't think like your typical lawyer. So I would always be trying to create my own things. And the best thing I ever did was come up with the domino theory. But even though it's the simplest thing, and there's a lawyer, Pat Malone, his name is. He wrote Fearless Cross-Examiner. He's a great lawyer in Washington, D.C. He hit it on the head. He said, that's one of those things where you see somebody do it, and you're like, how did I not think of that? Like, it's so simple.
Yeah.
And it is. It's the simplest thing in the world. But, nobody figured it out. It was the first one in 500 years of the law to figure out that the domino theory. I mean, it blows my mind.
Can you explain what that is for people that are listening that don't know?
Yeah, and how I came up with it. Even in law school, they kind of hide the ball from you. They don't teach it to you when they can make it so simple. And it's one of the things now I'm going to be doing is I'm going to be promoting this book at law schools. I'm doing a seminar at Rutgers in next month with the same guys who we did that last seminar with. And I'm going to talk to some of the professors there. I'm going to start marketing this book at law schools because it just makes it so much easier for somebody in law school to understand what proximate cause is. So proximate cause, for those of you who don't know, it's a cause that sets in motion a sequence of events. So if somebody's driving their car and they drop something on the floor and they look down to pick it up and they're being careless, they go right through a stop sign, cause a big accident. That's the negligence. But if they hadn't, taken their eyes off the road and weren't paying attention, they wouldn't have gone through the stop sign. They wouldn't have caused the accident. They wouldn't have injured the person. They wouldn't have caused that person to get all these surgeries and then not be able to do the things they used to do and lose, money from employment and then have medical bills out. So everything stemmed from just that guy looking down. So that was the cause that set in motion a sequence of events. And then if all of those events are dominoes, one knocks over the next one and so forth. And how I came up with it is like necessity is the mother of invention. I probably 30 trials in a row when during the jury's the jury deliberations, they would come back and say, Judge, can you redefine proximate cause? I'd be like, the charge, just to say what I just told you, is 4 pages long. It's the most convoluted nonsense you ever heard.
Yeah.
And this is what the judge reads to the jury who's going to decide proximate cause.
And if we don't prove proximate cause, we'll lose the case.
Yeah, and every case, and the most difficult
pull that mic a little closer to you.
The most difficult thing to prove in a trial is proximate cause. Well, every case is really tried on proximate cause, at least like the auto cases and some of the simpler ones. So that's ultimately the issue that you're going to win or lose on.
Right.
And it's such a simple concept, yet the courts, make it impossible for a non-lawyer, non-doctor, just a regular person who's going to make that ultimate decision has to understand what this stuff means. It's like a contract. That's why the people say, it's job security for a lawyer. I mean, the language of a contract is ridiculous. I mean, it could be so much simpler. And this is a perfect example. So one of these trials, and every time they would ask that to be, reread, so the next trial, I'd spend even more time on it, and then the next trial, more time. But regardless, they always ask for it. So when the last time they asked for it, I grabbed the charge, I read it. I'm reading it to myself, and I see a cause that sets in motion a sequence of continuous events. So I'm like, that sounds like dominoes. So after that trial, I went and got actually dominoes made about the size of cereal boxes. And I would put the facts of the case on these dominoes, including the negligence and the collision.
Like each domino is a fact,
yes,
or something.
And the first domino is the cause that sets in motion the sequence of events is the negligence. So that negligence, it's in red. Everything else is in black. And that's the domino that once that person looks down to pick up whatever he dropped on the carpet of the car while he's driving and goes through a stop sign, without that negligence, nothing else happens. But once that negligence happens, it hits the first domino, which is the collision, the airbag deploys, emergency, immediate onset of pain, emergency room, chiropractor, MRIs, EMGs, epidural injections, surgery, $2,000 in medical bills, $500,000 in future medical bills, lost income, can't golf, can't ski, can't, all that stuff is all caused by that one negligence domino. So, and when I started out, I used like 10 dominoes. Which the next trial, when I tried a case, was like 2 weeks, literally. I used to try one case every 2 weeks. I used these dominoes. I had a verdict in 25 minutes. And the funniest thing about this is the lawyer on the other side was an older guy who was a real jerk. He was treating me like I was a child, So I'm outside on the front steps. It was in Elizabeth in Union County. I'm out on the steps. He comes running out there. It was like 20 minutes after the verdict, the jury started delivering. We have a verdict. And I'm like, God damn it.
Yeah, and a quick verdict, it traditionally means you lost.
I
as
lost.
A plaintiff.
I'm so upset. I can't believe I'm losing. So we're walking back to the courtroom. He's, flaunting and, stuff. So I said to him, have you ever been, having a verdict against you in 20 minutes? He's like, not in 30 years, I haven't. Jury came back, negligent, yes, caused the accident, yes. And they gave me a nice verdict. I said, you have now.
Did you expect it to be a plaintiff's verdict? Or did you think, oh, no, you said you thought you lost.
I thought I lost just because of the time of it. But after that, I used them every single trial I've used them in, and I've won. I've never lost on causation using the dominoes. However, I have lost for other reasons, including a trial I did in West Virginia that I lost. It was like my cousin Vinny. I mean, it was hilarious. But it was one of the best trials I have actually ever put on, and I would have won that case if the judge, who hated me, didn't give me such a hard time in that case. But I did not have the dominoes in that case because when I went down there, and I was down there for like 2 weeks, I didn't think proximate cause was an issue in the case, so I didn't bring the dominoes. How it turned out that was the issue, though. That the way the case went in and like how everything panned out, it became an issue. But I didn't use them because I didn't have them with me, and I was, that's why I don't like. I try a lot of cases in other states and far away, and I don't like to do that. I mean, sometimes it's fun to do it because it's a different place and everything, but you're at a disadvantage, like law-wise. There are little cases that you don't know about, and if your local counsel isn't good, and you get hometowns like really bad in these different states, but. I would have won that case, I think, if I tried that case in New Jersey.
So when you're at trial and you got these 10, 20 cereal box-sized dominoes, where are you putting them at a closing argument?
Well, I'm up to 47 now. My last trial, I used 47 dominoes. Ironically, some...
Do you actually knock them and they fall?
Oh, yeah.
How's that work?
Well, you have to have the right place. For whatever reason, New Jersey is unique that almost every case I've ever tried, there's a jury rail that goes around the jury. Sometimes it's U-shaped. Sometimes it's literally U's, but with 90-degree angles. So funny, like usually if it's curved like a smile, which a lot of them are, it just goes right around the jury and falls right in front of the jury. And that's the last thing I do. And we go last, so I usually just walk away and leave them there. So now the jury's getting charged by the judge, and they're still sitting right in front of them. But this last trial I did, it was not a smile, but an actual U. So they had 90-degree angles on both sides of the jury box. And I had 47 dominoes. And I curved them around that 90-degree angle. I could just kind of cut the corner on it.
Yeah.
And it worked. And they went down perfectly. And the judge even said, how did you pull that off? I said, I don't know, but it worked. But what I did in my last trial, there was nowhere to put the dominoes. So there's a guy I work with, and it's Vince Maggiano from Dynamic Video Evidence. I don't know if you guys work with him, but you should. He's awesome. I'm telling him, there's nowhere to put the dominoes. There was just no jury rails, nowhere in the courtroom to put the dominoes. I said, can we do it digitally? So I would mention the domino, and it would drop down with the writing on it, just like the physical dominoes. And I did them, and then knocked them down digitally. It was on a big screen for the jury. I don't think it's as effective, but it worked, and I did win that case. But that's what I do if there's nowhere to put them.
So, but these aren't like gimmicks. This isn't gimmicks. This is a way to counter all the stuff we talked about that these insurance companies, these tricks they pull.
Well, the thing about them is, and when I lecture, because I've lectured in, I think, 35 states now with the dominoes, and I sell them, we make them and sell them. So there's been verdicts in almost every, I think all 50 states and Canada using the dominoes. So they're very effective. But what I tell people, I warn them, I guess, it's kind of like a caveat. You can't just use them and you're going to win the case. You got to kind of prove all of those elements happening during the case. All these tests occurred, what you're saying they said. Like, you got to prove it in the case. And it's kind of just to wrap it all up on a nice little bow at the end. But I get a lot of calls and emails from people who use them, like lawyers say, man, I just want to thank you. I just got a $28 million verdict. It's like 2 weeks ago. This guy from Texas called me and said, I got a $28 million verdict using the dominoes. I just wanted to thank you. And that means the world to me. I mean, that I guess there's some doing some good in the world. That it makes it easier for juries.
And it's not like, oh, I got a $28 million verdict. I really scammed them and got money.
No,
These are people that are really badly injured, and because of someone or some corporation or company.
Yeah, when you hear numbers like that, I mean, people are usually catastrophically injured, life-altering. I mean, that you would never trade your health in the world for that amount of money. And that's why when you hear stuff about like the McDonald's coffee case, that was a $7 million verdict.
I thought it was 700,000.
Well, I'll explain. No, it was $2.7 million. But this woman had 9 surgeries. She did fumble with the top of the coffee lid. It was partially her fault. But when she spilt it on herself, she shouldn't have had to have 9 reconstructive surgeries, because they sold the coffee so hot that people couldn't drink it for a while. The purpose was so they bought more food, like that. If you were in the restaurant and you couldn't drink the coffee for 15 minutes, you would be able to buy more food. That was the purpose behind that whole thing. And there were 700 prior cases against them.
Yeah.
And all she wanted was $20,000 for her medical bills, which they didn't give her. So even though what that $2.7 million was, when the jury found out that they had 700 prior complaints, this was a punitive damage award. And what it was all of the profit that they made in one day from coffee sales. That's $2.7 million. The judge ended up reducing it to like $400,000. She was found like, I think 40% liable. So I think she settled the whole case for $140. I think the total settlement was $140,000.
It was a state with a cap too, right?
No, that didn't have. Yeah, no, it was. I want to say it was New Mexico. No, there was no cap. If there was a cap, it didn't reach the cap. It wasn't the cap. It wasn't the issue. The judge just remitted it. Reduced the verdict.
I didn't know a couple angles of that. That's wild.
Yeah, there's the hot coffee documentary. If you watch that.
I watch it on HBO, I think.
Yeah, I have it on video. But there's another case on that video. There's 3 cases. That one and like a really sad medical malpractice case involving a child, where it was in Texas, I believe, and there was a cap. And $250,000 or something. The verdict was like $7 million, and the kid needed treatment for the rest of his life. So even at $7 million, the verdict, whatever it was, would be difficult to take care of this kid for the rest of his life, and they reduced it to $250. I mean, it was like peanuts, a year's worth of treatment.
I'll take a little free insight here. So what do you do when you're setting up the dominoes and the defense argument in the case is that there's these pre-existing conditions, or they had this prior complaint or this prior crash? How do you treat that?
Well, it's actually the best part of the dominoes when I set them up, because when I set them up, the first one I have, and it depends on how much history there is of this person. This person might have 2 prior accidents. He might have MRIs with findings. I'll put those dominoes in front of the negligence. So those are the first ones I put. Okay, you heard my client in 1979 had this accident and this injury and this accident, this injury, and then the negligence occurred where the person ran the stop sign.
You could probably put those 2 dominoes like far away. Because nothing occurred in years between.
The reason I don't do that is because then I take the negligence domino away. Then I knock over those. They all go down. Nothing else happens past the negligence domino. Then I just get rid of those. But the negligence did happen, and all this stuff did occur. So I kind of disproved their case, and then I proved my case. And like I said, if you can really go into depth about any prior stuff, and it's not the end of the world if somebody has a prior 5 years before your accident, and the MRIs are different, for example. Because usually, say you have no prior issues, you're 40 years old and you have an accident. The defense has literally a 25-year window to say, it's somewhere along here the degeneration occurred. When you have a 5-year window, I know what it looked like 5 years ago. Yeah. Now I know what it looks like now. So it's, you have a brand new herniation. Well, where'd it come from if nothing else happened? So it's almost easier to prove, but ideally you want an 18-year-old with nothing.
Yeah.
But the pre-existing stuff can be disproven.
I'll say something real quick just to comment, because I think it's funny. You start off, Jerry, saying kind of jokingly that we're all competitive in here and stuff. But there's such a like in our field, there's such a sharing component of it. Like you sit there genuinely happy for the guy that hit for 28 million. You published a book to share kind of your secret sauce with some of the stuff. Why is that? We talk about guys like Rick Friedman that write these books. Like, what is that in our profession that we want to kind of help each other out?
I think that, and believe me, if I go to a seminar, whether I'm speaking or not, or just during a regular week, I have my paralegals want to kill me because they get so many phone calls from other lawyers that want to talk to me about stuff. And I don't know, it just feels good. I love it. I love the law. Like me and the lawyers that work together at my firm, one of them is actually my son. We hang out all the time. We go to a lot of sporting events, Yankee games, Ranger games, whatever the Kentucky Derby. We do a lot of things together, but every time we're together, we're always talking about the law. We're not talking about anything else other than maybe sports, but primarily it's the law because we all love it and we're passionate about it. The one thing because people ask me to share this information with them, which I do, but I think most of the people that I talk to, a lot of those guys I was telling the spectators with Mike Maggiano, Chris Plastella, Mike Ferrara, this guy Don Camaraderie, these were the guys when I started to be a lawyer that I really looked up to. And I wanted to be like them. And now I am, they kind of brought me into their little circle. And I was much younger than them, 25 years younger than them. But they brought me into their circle, and I was flattered by it. But, to share the information, I was more worried that the defense was going to find out, like, what I was doing and then, stop me somehow. And then I said to myself, well, they have every transcript of every trial I did. Like, if they want to get me, they can get me right now. But the funny thing is, like, I would know when I would try a case, I would know what they were going to do. And they thought they knew what I was going to do. So as soon as the trial started, I would go in a completely different direction. And they would be like, what is he doing? Like, I would always find a way to do something different.
It's deceptive warfare.
Yeah, it is. Like I said, and I have 9 Army tanks, and they have 1. So I would always bring in a ton of experts and just try to pummel them into the ground.
So you have 9 Army tanks, but you also have 9 decoy Army tanks that look like Army tanks, but they're not. So when they come in, they're doing their surveillance, seeing what you're going to do. You got 9 Army tanks lined up on this shore. They put all their defenses there, and then you battle them. You come in from the west instead
like
of the
D-Day.
east.
Instead of Calais, I went to Normandy. They think I'm going to Calais, but I'm going to Normandy.
That's funny.
Yeah. So and I think you have to be creative, and some things happen. I think what makes a really good trial lawyer, and you guys, I guarantee you feel the exact same way. Something in every trial always happens that you're not prepared for. And it just happens, and how you react to that, on a dime, that makes a good lawyer. You think on your feet because things happen that you cannot prepare for. It happens.
I had a trial once, and I won't say the judge, but I'll say New Jersey, and I won't say the county. And this judge was just so anti on my case, but she was also equal. She was like equally anti to the defense, and the judge wouldn't allow us to speak really much. She would ask a question, and I'm just pulling it out of the hair because it was a while ago, and she literally wouldn't let us talk. Was completely commandeering the trial. It was terrible, and she bifurcated liability and damages, meaning was going to limit the trial only to liability because liability appeared a bit more difficult than the severe injuries.
I guarantee I know who you're talking about.
I know who you are, but we won't say it. We won't say it. And it was really the most miserable trial experience I ever had. But this judge was so over the top that we won liability within 45 minutes because the jury didn't like the judge either. And it was so obvious she was trying to get us to lose the case. And just to tell people the power of the judges, guess what she did after we won liability?
What?
Judgment notwithstanding the verdict.
Exactly.
Really? Wow.
Exactly. We took it up in appeal and all this. But that goes to what you're saying. You have to be nimble on your feet. And, sometimes, Rick Friedman has a great line. And I don't know, I'm such a Rick Friedman fan, but he's got such a great line in one of his books. You don't want to be too high and you don't want to be too low because He says some of the trials that I tried the best, I was perfect, did everything right. The defense lawyer was bumbling around the courtroom. I lost. And some of my biggest verdicts are cases where I had no business winning them at all. You know?
Yeah, like I said, there are cases. I've lost plenty of cases. I don't win every case. I've lost plenty, but I've won a lot too. But most of the ones I won, I should have won. I think a lot of the cases I lost earlier in my career, I would have won now because I'm smarter. You know,
Right.
But I win a lot of cases. Well, yeah, I have no business. Everybody was like, "You're not winning this case," you know. I mean, one of my most famous cases is this AGA case. This is it's a jury
the
charge
MRI
now,
case.
Yeah.
Yep,
The
AGA.
MRI hearsay. So I tried that case without the films being read in court. And this is the stuff, you can't make this stuff up. And I don't even know if anybody knows this, but so the MRIs were read by a doctor while I was trying the case. We're in the hallway and he's reading the films and he's like, "I'm not saying that's a herniation," because it said there was a herniated disc in the hospital where he had the MRI. But the signature for the doctor was Rad Default MD. So I had Rad Default on my pretrial. I was going to call the guy. So the doctor's saying in the hallway, saying, "I'm not saying that's a herniated disc," but he just went into court, and at the time they could rely on the findings of the reading radiologist. So he said, "I said, did you agree with the radiologist?" He said, "Yes." So the defense lawyer, who was really good, I don't think he had ever lost a case. Not only that, he was very mean to me, and he ultimately became a judge after that. But he said, "No, you can't. I can't cross-examine him on this document." And he was citing a case which I can't. Naraki, it was called, where no wiki.
Yeah, that's it.
No wiki, that you have to have the reading radiologist. Mm-hmm. And I said, "Judge, I'll call the guy right now. I have him on my pretrial. I don't care." And the judge's like, "Nah, you don't have to call him." And I went in. I won the case. And my client was an Arabic fellow, and he didn't speak English, so he was speaking to an Arabic interpreter. And this is, 2006. It's kind of close to 9/11.
Yeah,
There's still a lot of animosity going on. And I ended up winning the case. It was like a $55,000. I think it was $55,000. It was not a big verdict. So they appealed it and went to the appellate division. I lost, and they reversed it, and I lost. So I got 0. So we went to the Supreme Court where they granted cert. I argued it, saying that I relied on this. The judge told me that I didn't have to call the guy. I had him on my pretrial.
Yeah.
And they said, all right, they remanded it for another trial. Now I try to find Dr. Default. Rad Default means radiology default. It's not an actual doctor.
Oh, my God.
So
no one through the whole system
figured
picked up
out.
on it?
Even the
Dr.
Supreme
Default.
Court didn't figure it out.
Holy crap.
And then when we had to try the case again, I had to find the radiologist. I'm calling this hospital. I'm like, "Where's Dr. Default?" They're like, "That's a radiology default. There's no Rad Default here." Wow. So I had somebody else read the films. Went back in there, tried it again. In the meantime, now I think I'm 7 years late.
Wow.
7 years after the accident. Now I'm trying it. The guy had no treatment in 7 years. It was crazy. And I won the second time again for the exact same amount. Same amount.
Wow, that's crazy.
55 grand. So it was a small verdict, but for me that was my greatest verdict because I won it twice.
Yeah.
With an Arabic speaking person and the Arabic, the interpreter is like praying to Allah putting the blanket down and praying.
When a certain time of the day came.
Yeah, and the jury is an all-white jury, and I'm like, "What are you doing? I'm going to lose this case."
Yeah.
A very difficult case, especially the second time around, and to win it again, And then now it's model jury charge.
Yeah,
so
that's cool.
Became
Really cool.
something, but I don't think a lot of people would have spent the time and the money and taking it all the way to the Supreme Court and fighting for the client because you already lost money from the trial and the first one.
So I think you have anyone closing up a little bit. You have anything you want to jump in before I?
I do. Ed, again, this happens all the time with guests where we feel like we could talk to them for hours. And you clearly, again, we're in the same profession. We're fighting the same fight. It's the same deal. I do have just one or two more things I want to hit with you. I feel like you can tell I'm on trial. Yeah. Wait, I'm saying just one or two more questions.
Yeah.
But I am kind of fascinated by your background. You said you're a musician, but I take it you were more than just a musician. Like you're touring the world, you're putting on these concerts.
Yeah.
How that, if at all, helped you with the transition to becoming a trial attorney?
Well, the funny
And to where I'm at, there's a big thing. There's a book, Theater for Trial, and I know that some trial lawyers will actually take acting lessons. Again, not because they're acting or pulling the wool over the jury's eyes, but because it's different techniques to expose the truth. And so, yeah, like.
Well, my brother is a lawyer, and he's the one who, when I was a musician, I had done it for like 20 years. I was literally on the verge of death. I mean, just the traveling and the partying and the craziness. And he, saw me one holiday, I think it was Thanksgiving, and he's like, dude, you're going to die. You got to, why don't you go to law school? Why don't you go to law school? I'm like, get out of here. I'm not going to law school. And then I broke up with my girlfriend. I just had a lot of stuff was going on. I said, you know what, I'm going. And I had to finish my undergrad, so I went back to Penn State, finished that.
How old are you at this point?
I'm 30, 37, 35, 34 maybe.
When you
33. I think I'm 30. I was 33 at the time.
Yeah,
33 or 34. So I was a little older than everybody else. So I finished my undergrad and went right to law school. And I said, it's going to take me 4.5 years, and it took me exactly 4.5 years. And, as a musician, I had done probably between 2,500 and 3,000, performances as a lead singer, guitarist in a band, several bands. I had a lot of exposure to people. So when I then became a lawyer, and I was nervous when because I wasn't nervous as a performer because I was good because I had been practicing for 20 years. I knew I was good, so I was cocky and confident. So when I first became a trial lawyer, I was a little nervous because this was a whole new ball game for me. But because I had some quick success, then I got cocky and back to as if I was a performer again. But I read the Johnny Cochran book, and because people say, how do you go from being a musician to being a lawyer? And in the Johnny Cochran book, he says the best lawyer he knew was a former musician who worked in the prosecutor's office, who had a rapport with the jury that you could never. I mean, he was so in touch with these jurors. So after I read it, I said, now that makes sense, because you're in front of people, you're dealing with all kinds of people as a musician. Now you're dealing with all kinds of people. And because and like I said, I had to be myself. And I'm a blue collar, I think that's just the way I am.
Notwithstanding the big house you live in, but keep going.
Well, I grew up in my house, my mother's house, which she still lives in, that I grew up in, could fit 10, could fit 20 of those houses. We had one bathroom for 6 people, So, I don't forget where I came from,
I got it.
But
there's nothing wrong with being successful and making money in America. So that's great.
And you know what? And I'm sure you guys do it too. But I mean, when I try cases, or if I'm going to settle a case, and I'm a lot, like I said, something I lost track of earlier, I'm a lot wiser now, and I've calmed down quite a bit than how I used to be. So when I have clients now, instead of promising them, if you lose the case, I'll give you the money.
Yeah.
I'm like, listen, if you were my brother or you were my sister, I'd tell you to settle the case. I'll cut my fee.
Yeah.
Just to show you, look. I want you. This is the only case you have. If I lose this case, which we could very easily lose,
yeah,
you're going to get nothing. I said, I'm going to try another case next week, but this is the only case you have. So, why don't you just settle it? That's my advice to you.
Yeah.
Don't be a hero. Even if you win, they're going to appeal it. They're going to drag it on. You can have this money in 30 days. Just take it. Do me a favor. Just take it. And, so, it's not all about the money. I mean, thank God we make enough money to have a comfortable life. I mean, we're not. The funny thing is, with all this stuff, like with the taxes they have now, I never had any money. So, if they now we're going to tax people if you sell a house worth more than $1 million tax. Now you have a millionaire's tax. You have this. I'm like, now that I have money, now you're going to take half of my money.
Yeah.
All the years I had no money and nothing and paid like my fair share of taxes. I'm still paying a fair share, but come on, I got to pay half of the money. Yeah. It is annoying, but
that's funny.
Yeah,
with the musician thing, I just picture if you're standing up there in front of 100 people, 1,000 people, you're reading the room, working the room. Makes it a lot easier when you step into a courtroom where you got 7, 8 jurors, 6 jurors sitting there.
It is if you're confident in yourself, and I said that's why it took a little while for me to become confident. And I think just the success gave me that confidence. And then when I do if I have a trial, there's 50 lawyers are watching me. Every trial I have, there's at least 50 lawyers in the watching me open or watching me close. The judges, they bring in all their law clerks from every courtroom to watch me do the dominoes, So it's flattering, But I do like it. I mean, I've always liked what I did. I mean, I say this all the time. Now I'm lying when I say it now, but Oh, I never worked a day in my life. I would be in my office at 5 a.m. I would be driving to work with a smile on my face, like, I'm going to go do what I love. I'm not smiling no more. That's gone away from me. But I did for probably the first 20 years. I loved going into the office and working, and trying these cases. But I'm old and tired now, so I'm not as enthusiastic as I once was.
Do you have any regrets, like when you look back on it? Would you have changed anything? Maybe just gone a little slower or a little so you could,
Well, one of the things
last longer, so to
the
speak?
things that I regretted starting so late in life, like I would always say, man, I'm so far behind. Like, it took me, I didn't just, walk in to become a lawyer and become rich overnight. It took, 5, 6, 7, 8, 9, years to kind of get rolling, I guess. And I'd say, I wish I would have, gone to law school sooner, but then everybody'd say, well, yeah, well, then you wouldn't have like that last 5 years experience as a musician, and this wouldn't have happened and that wouldn't have. So then I say, yeah, you're right, But because my first 35 years of my life, I was living hard and crazy. So if I had just gone to law school, like I have a son who's one of my partners now at my law firm, and he went to Penn State.
What's his name?
Alex
Capozzi.
He argued in the Supreme Court yesterday.
Awesome.
So, and I think he's tried 10 cases, won all 10.
Wow.
But he doesn't act like me. He's got a different personality, but he's a very talented lawyer. So he went to Penn State, then he went to Rutgers Law School, and then, started working with me, and then ultimately became my partner. But so he's, ideally, that's the way you do it. You go to college, you become a lawyer, then you go straight to law school, and then you're a lawyer at 25 years old. 25 years old, I was in Germany, drunk on a sidewalk, passed out in the snow, outside a club. So, it's just a different path,
All right, well, listen, next time you come on, you got to show us your tattoos.
I'll show
I
you.
know you got some beneath that suit somewhere.
10.
That's funny. Would have thought that.
Yeah, thanks for having me. I really appreciate it. It was fun.
No, yeah. Thanks for everything you've done for our profession and New Jersey trial lawyers.
Yeah, man, anytime.
And listen, we're humbled and that you come on. We really appreciate you coming on, and honored to have you here. And thank you for the contribution you made to the profession and to the people in New Jersey and the greater part of the country that need help from people like you.
Yeah, thanks, man. Look, you've done a lot too. I've admired you from afar as well, so I appreciate that.
Thanks. Awesome. And if you come on next time, we'll do the Clark way and not wear suits.
Okay. Yeah. Well, it might be in the summer. Wear my,
yeah.
Wear my beach attire.
Yeah, exactly. All right, thanks.
Thanks, man.